Madam President, as I've done from the time that he was nominated, and as I will continue to do until he's confirmed, I rise to support the nomination of Neil Gorsuch to serve on the Supreme Court. Judge Gorsuch is an accomplished, mainstream jurist. I look forward to helping make sure he can receive a vote here on the Senate floor. In the week since his nomination, I've spoken at length about his qualifications to serve on the Supreme Court. I've recognized him as a conservative champion of religious liberty, a defender of the separation of powers, and a Westerner who will bring some much-needed diversity, geographic diversity, and a regional perspective to the court. During his confirmation hearing before the Senate Judiciary Committee, Judge Gorsuch showed the country what it means to be a judge. Big or small, popular or unpopular, powerful or powerless. Judge Gorsuch promised to render judgments based on the facts of the case, nothing else. He also has a remarkable record of respectful cooperation with judges appointed by presidents of both parties. During his decade-long tenure on the 10th Circuit Court of Appeals, Judge Gorsuch participated in more than 2,700 appeals. These comprised of some of the most difficult cases across 6 states. Of those cases, 97% of them were decided unanimously. 97%. And Judge Gorsuch was in the majority 99% of the time. He was in the majority on those cases 99% of the time. This is a testament to Judge Gorsuch's ability to consider other points of view and to seek out consensus where possible. To try to paint Judge Gorsuch as an ideologue simply doesn't work. These are essential qualities for any prospective Supreme Court justice. Madam President, now that we have reported Judge Gorsuch out of committee as of today, I'd like to say a few words on the obstacles that stand in the way of him being considered here on the Senate floor. As we proceed with Judge Gorsuch's confirmation, I'd like to explain my support for confirming him in light of what transpired in the waning months of the previous administration. For nearly 230 years, presidents have been making nominations to the Supreme Court. According to the Congressional Research Service, quote, from the appointment of the first justices in 1789 through its consideration of nominee Elena Kagan in 2010, the Senate has confirmed 124 Supreme Court nominations out of 160 received. I'd like to reiterate that number. Of 160 Supreme Court nominations in our nation's history, 124 were confirmed. The Congressional Research Service goes on to state that, quote, of the 36 nominations which were not confirmed, 11 were rejected outright in a roll call vote by the Senate, while nearly all of the rest, in the face of substantial committee or Senate opposition to the nominee or the president, they were withdrawn by the president or were postponed, tabled, or never voted on by the Senate. Madam President, the manner in which the Senate decides to provide its constitutional advice and consent to presidential nominations has varied over the centuries with respect to nominations. This includes decisions not to take up Supreme Court nominees. As Jonathan Adler put it in his article in the George Mason Law Review, quote, much as the Senate may reject a legislative proposal that originated in the House of Representatives by voting it down, killing it in committee, or simply refusing to take up the measure, the Senate may withhold its consent by voting against confirmation of a nominee, rejecting the nominee in committee, or simply refusing to act. Is refusing to act the preferred outcome? I certainly see where some would say no, as would I. However, the history of the Senate demonstrates that to do otherwise in similar circumstances as we just experienced is in fact a rare exception. To cite Adler's Law Review article, again, he states, quote, the last time a Supreme Court vacancy arose in the calendar year of a presidential election and was filled prior to the election was in 1932. So, when President Obama nominated Judge Merrick Garland to the Supreme Court in the heat of the 2016 presidential election, When he was nominated, I understand the frustration of those on the other side of the aisle over the fate of that nomination. I met Judge Garland. He is a good man and a good judge. But the decision by the majority not to take up Judge Garland's nomination was not inconsistent with the long-standing practice of filling Supreme Court vacancies after elections. This brings us today to why I'm supporting confirming Judge Gorsuch to the Supreme Court. There is no question about the appropriateness of confirming Supreme Court nominees during the first years of a president's term, let alone the first 3 months. In fact, there is absolutely no justification for filibustering a highly qualified Supreme Court nominee put forward by the president that was just elected. That is just unprecedented. There was an attempt to use this tactic in 2006 with Justice Samuel Alito's nomination to the Supreme Court, but he garnered sufficient bipartisan support so that cloture was invoked. Today, it appears, we will not enjoy that same rational support. My preference would be to change the behavior of senators rather than change the rules of the Senate. But here we are, where a nominee who would have received unanimous or near unanimous support just a few years ago is about to be filibustered. My question is this: if we can't confirm a judge like Judge Gorsuch under contemporary use of Senate rules, who can we confirm? It looks as if we'll move forward later this week and make the rest of the executive calendar subject to the same simple majority threshold. Again, a change in Senate rules is not my preferred outcome. But this rule change will simply make de jure what was de facto prior to 2003, when filibusters were virtually never used on the president's executive calendar. Now, I want to make clear my steadfast support to preserve the legislative filibuster. We need to distinguish here between the president's executive calendar that has traditionally never been filibustered or subject to filibuster, and the legislative filibuster that is used frequently here to ensure that we work across the aisle. The framers of our Constitution had the wisdom to create a Senate with a strong minority to serve as a check on runaway power. If we were to eliminate the legislative filibuster, we would cease to be that check, and indeed, the Senate would cease to be the Senate. Madam President, we have a qualified, mainstream jurist before us. That is Judge Gorsuch. I encourage all of my colleagues to give him fair consideration and to advance his nomination to an up or down vote. I will be voting to confirm him, and I urge my colleagues to do the same. I yield back the balance of my time.